Mr. Coleman, can you hear me?
I can.
Excellent. Mr. Anderson, can you hear me?
I can, Judge.
Excellent. Thank you. We will go on the record in the matter 24 CT47 24 TR 210, State of Wisconsin versus Clint Coleman. The state appears through District Attorney Kevin Schmidt in person. Mr. Coleman appears by telephone conference with approval of the court. His counsel, Bruce Anderson, appears by video conferencing capability, again with approval of the court. We're set here today in this matter for a status conference and essentially a final pretrial. The court has received a memorandum from the state, which the court did go over with Mr. Anderson. I believe it was a few days ago on January 13th concerning discovery and the video that the state intends to play at the jury trial. Mr. Coleman was unable to appear at that hearing due to the fact that it was short notice. The court wanted Mr. Anderson to have the ability to review that discovery and that video and to be able to speak with Mr. Coleman and give one last shot to figure out the matter if it's able to be resolved.
And here's where the record scratch happens. The state says the defense never even asked for the evidence. That's like walking into a duel without checking if you brought your sword.
Scheduled for this coming Tuesday on January 21st. Mr. Anderson, can you please update the court?
Well, yes, Judge. I have not been able to talk to Mr. Coleman about this. He had called my office this morning, as I expected, and then called back and said, well, I was in court in Polk County, and then called back and said that his phone was difficult and that he would appear at the hearing once he found another phone. So I've not talked to him yet today.
All right.
The court was told him. Yeah.
So I am going to read the memorandum in the record. Memorandum from the state on January 8th, 2025 to Honorable Melissa R. Mogen from Kevin Schmidt, District Attorney, Ray, State v. Clint Coleman. This memo is to the court to update it on the state's attempt to comply with the discovery statute, the scheduling order, and protect the case against any claims of ineffective assistance of counsel. While preparing for trial, the state noticed that the defendant has never filed a discovery demand and therefore no discovery has been provided. The state intends on relying upon body cam footage that depicts the defendant highly intoxicated, hugging a deputy and telling the
Body cam evidence plus a hug for the deputy plus a confession? The prosecution isn't just holding cards. They've got the whole deck, jokers included.
loves him, admitting to driving, admitting that he shouldn't be driving, and other significant admissions. The state is providing discovery today, even though it has not been demanded. The state is concerned about the possibility the defendant has made the decision to go to trial without actually reviewing the evidence of the case. Thank you. Electronically signed, Kevin Schmidt, District Attorney. So that is the memorandum, and that basically gives a gist of the body cam footage that the state intends to play at the jury trial on Tuesday. I need to have Mr. Anderson have time to speak with Mr. Coleman, and I need to have it done today, and I need to have a hearing, a status today, because we are on the tail end of time here with the jury trial scheduled for Tuesday. And again, it is scheduled to go on Tuesday. So, Mr. Coleman, when can...
Trial in days, zero review of the main evidence. That's the legal version of skydiving before checking if the parachute's packed.
To have a very in-depth, thorough conversation with your attorney today.
As soon as we get done with this hearing, I suppose I'd call him.
All right, Mr. Anderson, are you able to have an in-depth conversation with Mr. Coleman right after this hearing?
I am, but I'm hopeful I can speak one more time with Mr. Schmidt before I have that conference with my client.
All right, Mr. Schmidt, would you be available to go speak briefly with Mr. Anderson before he calls his client, Mr. Coleman?
Yes, I can be available right after this hearing.
All right, so what I am going to do is schedule this matter 3 o'clock today for a status and update, a final pre-trial. All right? Mr. Coleman, you need to make yourself available at 3 o'clock today. You may call in just as you have done here today, okay?
Okay.
Mr. Anderson, 3 o'clock today. Mr. Schmidt.
At 3 o'clock, what I'm going to be asking the court to do is ask the defendant to acknowledge that he has seen the body cam and that he's still rejecting the offer. The state's main concern is Ludwig,
all
not...
of that stuff,
yes.
but I can't say that he's seen the body cam because I'm going to guess that he's not going to be able to see the body cam because he's at work. Mr. Anderson is at probably his job too, doing court stuff in other courts or at his office. All I can say is that he's probably going to go over exactly what happened on the body cam with Mr. Coleman, go over his thorough negotiations, settlement negotiations with Mr. Coleman, and he's going to have a thorough discussion with Mr. Coleman of the ramifications of the evidence in this case and what it means for Tuesday. That's all I know, and I'm going to go over with Mr. Coleman at 3 o'clock if he understands the agreement or, the offer that's been presented, and if he wishes to accept that offer or formally reject that offer on the record.
Okay, thank you.
And then we will see where we're going at 3 o'clock. All right?
Thank you.
Mr. Anderson?
Yes, it's fine.
All right. Then everything's good. And so once we adjourn, Mr. Schmidt is going to go right back to his office, going to expect a call directly from Mr. Anderson, and then Mr. Coleman, expect a call directly from Mr. Anderson, okay?
Okay, can you tell him that I'm going to call his office with the phone number that he can get a hold of me on?
Can you
Do that
call-
right away. 'Cause I'll be talking to Mr. Schmidt.
I'll do that right away. I'll call your office with the phone number and call me back on.
All
Okay.
right. There
Judge,
you go.
can you hear
Can
me
you
now?
hear? Yes, I can.
All right, thank you.
All right, we will go on the record in the matters 24 CT47, 24 TR 210, State of Wisconsin versus Clint Coleman. The state appears through District Attorney Kevin Schmidt in person. We have Clint Coleman appearing by telephone conference with approval of the court. We have Bruce Anderson appearing by video conference, again with approval of the court. We're set here today in the second hearing today for a status conference and a final pretrial. The parties were given an opportunity to discuss certain discovery, a body cam video, as well as discuss further negotiations and with regards to settlement. Mr. Anderson was given an opportunity to further discuss the matter with his client, Mr. Coleman. Mr. Anderson, can you please provide the court with an update?
Certainly. Excuse me. I spoke to Mr. Schmidt after the earlier conference, and he indicated to me that he would have no objection if my client wanted to enroll in an IDIP program. I'm not sure of the status of Burnett County's program, and going through things then later with my client has decided to abandon his defenses.
This is a defense equivalent of folding your hand before the flop. Cut losses, take the deal, and live to fight another day.
Defenses, I guess you should call them, and accept the opportunity to enroll in the IDIP program whenever that can be done.
All right, here's the deal. I am set for trial and ready to go with the number one analyst. I usually don't do this, but since I am set with the number one trial and this final pretrial was just put on due to oversight, what I am willing to do is do what some counties do and take the, No, it's an OWI-3. I'm not willing to take the, well, has he sat 48 consecutive hours?
Clint, were you in jail for at least 48 hours?
No, I was not.
How long were you in?
A couple hours.
All right,
Okay.
so what would need to happen?
$540 up front just to get an ankle bracelet? That's not punishment. That's a subscription service to your own house.
48 consecutive hours. I'm willing to sentence pursuant to IDID guidelines, and giving him the time to finish that within a period of certain months, and then we can have a final status to ensure that he's completed that, even though it has occurred after the plea and sentencing. So I'm
So
not
what
sure
you're-
if you need, go ahead, Mr. Anderson.
So what you're saying is you would like to do the plea on Tuesday, I assume.
Well, no, I
He
can,
would-
if I can take him at his word and take you at your word, and if he needs time, because he would need, it's an OWI third, so it's an immediate report. I'm going to presume he needs time to set it up with work, etc., to sit 48 consecutive hours. So I will take you both at your word that that's what's going to happen, just like I would take him at his word that he will complete the IDIP, and I will follow up at the end, but proceed with plea and sentencing under the IDIP guidelines. So I am willing to then remove my jury trial for the 21st, and take a plea on a different date and time that would work for Mr. Coleman, with his schedule, knowing that he would need to sit 48 consecutive hours.
I understand. I think that is certainly doable. Not certain how long it's going to take him to get set up with the IDIP, but I'm
And
sure
again,
we can.
I'm not worried about that part. That can be in
Okay.
total after the plea and sentencing part, because it's going to take him 4 to 5 months to even complete that.
Right.
And as I stated, I'm willing to follow the IDIP guidelines for sentencing because that would be the deal. I'll follow the guidelines pursuant to the agreement. He'll complete the IDIP program as required, and then at the end, when he should be completing it, we'll have a final status and ensure that it's completed.
And I think what I'm saying is the best time for a plea hearing then too would be on a Friday, so that he could serve the 48 hours over the weekend.
And if that
So-
works for Mr. Coleman, then that works for the court. Mr.
Okay,
Coleman, is this all accurate and true?
Yeah, we can do that.
All right, so we're looking for a Friday. I could do as early as January 31st at 9.
That works for Anderson.
Mr. Coleman, would that work for you?
Yeah, that's fine.
All right, we'll schedule a plea and sentencing for January 31st at 9. Mr. Coleman, so you know, I'm going to assume and presume that there will be argument for electronic monitor after the 48 consecutive hours, and because that would be under IDIP. With an OWI third, with the
Money
C
order.
that you would have, that would mean that it would be 55 days, but there would be good time, but you would need to pay 30 days in advance, and it's $18 a day. So you would need to have $540 cash or check or money order with you on the date of the plea and sentencing, okay?
Friday the 31st.
Yes. And that is so you can be hooked up on the monitor Monday morning.
And cash is fine?
Cash is fine, yes.
Okay.
But that's just for the monitor, and that's just for the first 30 days. Again, there'll be more fines and fees and all of that other stuff, but we can address a payment plan at the plea and sentencing, okay?
Okay.
All right, anything further from you, Mr. Schmidt?
No.
From you, Mr. Anderson?
No.
All right, then the court will remove the jury trial for Tuesday. And the other matter is going to be dismissed and read in, I'm going to presume, yes, okay. Thank you, then we are adjourned. Cheers. We will go on the record in the matter 21 CF 138, State of Wisconsin versus William Barber. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Barber in person. We have Agent Amber McDowell by video conferencing. We're set here today in this matter for a probation review hearing. Mr. Barber, in reviewing the documents that have been provided to the court regarding your probation, I haven't been provided if you've had any violations or anything like that, but there's $518 outstanding. You haven't made any payments on your fines and fees.
Procrastination is not a course I took since I've been sober, worked on my daughter, got
Rehabilitation
construction thing.
Did you do all of this on probation?
I've done all this on probation. Amber, she either has copies of it or, what I've did my HSED. I'm working on my license right now. I have February 17th to go for my assessment. This is the last time you've seen me.
Oh my goodness, Miss McDowell. Like, these are all super positive things that I'm going to tell you I wasn't expecting. And I'm so proud of you. I'm so proud of you.
Miss Mogen, I would just like to address the court. When I was sitting here 3 years ago, I think Racky's not here no more, right?
No.
Well, what I was saying, I remember this. He was telling me from that chair that I'd reoffend, that I was high on that scale you have for prisoners. Made me feel bad. Not to the point of I know he was right. It was just the point that I knew my chicken was getting out of hand. And I've been sober almost, it'll be 4 years, February 10th, since the day my wife decided, she didn't have to bail me out of jail. She didn't have to, but she did. She gave me that second chance at what I'm doing today. And I take in consideration that there's spirit runs and stuff that I do, ceremonies and stuff I do. I've been doing funerals. I just helped out a little kid yesterday, his 16th birthday, helped him put in a shot because he got his license yesterday. I worked till 7 o'clock last night, helping him put in his lights and helping my boss put in that shot and getting his truck going for him because we were invited to a birthday party that I didn't even expect. I did a funeral a couple years ago for a 16-year-old boy that OD'd on fentanyl in Stillwater. Me and Perry Staples did that funeral. I've done a few funerals since then, for young kids. Some of them my parents, my greatest teacher, Lewis Taylor, the tribal chairman of St. Croix. I did that ceremony too. I'm pretty well respected around my tribe right now with all the things I'm doing, this side, that side. And you can go, I've been to that ocean that way, and I've been to that ocean that way. I've been all over the world in my young 50 years without an education, without anything. But in the last 4 years, I've been to Oklahoma for an AODA conference. She knows about it. Well, I don't know if she knows about it, but the one I had before, I can't remember her name. She worked over there. I've had 4 different probation officers since Amber, So each one of them's got a story of my life that I've done in the last 4 years. I got my education. Tomorrow I start college again for our sovereignty building. I'm learning how to process meat tomorrow. Maintenance job. So they want me to take my education right now. And we have a processing building over there that we'll be working on, animals, like a processing place. Well, I start tomorrow on becoming a supervisor over there and help run that place because they don't have anybody. It's noon, so the classes all starting tomorrow for maintenance, and I maintained my job even before I went to jail. I've always had a job. I've always worked. My kids, getting my daughter's trust back in that relationship is priceless.